Justice Bhagwati, you retired from the Supreme Court a little over a year ago. It was by any account and by any sort of opinion a very illustrious career in the Supreme Court. And I think for most people, most significantly, your name is associated with public interest litigation. Yet I would imagine that not many of us understand the notion of public interest litigation and its implications. What are these?
I think I should begin by pointing out as to how this idea of public interest litigation first stirred in my mind. See, when I became a judge in the year 1960, I was trained in the British tradition. I believed in administering justice according to law without realizing what law really is or what law really means. But when I became the Chief Justice of Gujarat, I had occasion to go to the rural areas. And when I went there, I saw for myself stark naked poverty. I saw men and women who were living a life of want and destitution, who had hardly a roof over their heads, hardly clothes to wear, and hardly 2 square meals a day. They looked at me with awe and wonder since I was the Chief Justice. But they had only seen the majesty of the law. They had never felt its justice. And then I realized how hollow was the justice I was administering in my court. So, and then when I started thinking, I felt that one of the greatest impediments in the way of the poor to access to justice was our doctrine of locus standi, as we call it in law. Put it simply, it means that if a legal wrong or a legal injury is caused to a person, he alone can go to a court of law for redress. If a legal injury is caused to you, I can't go to a court of law, you alone can go to a court of law because you must have a cause of action. Now, this principle is a principle of the Anglo-Saxon jurisprudence which we have inherited from the British. This principle served the community quite well when the entire litigation was in the area of private law, following the private right duty pattern. But so far as the poor people were concerned, this principle closed the doors of justice to them because, as I said, they lacked awareness, they lacked assertiveness, and therefore they could not take action in a court of law to vindicate their rights.
How many public interest cases have there been?
Oh, there have been fairly large number of cases, and the reason is, I'll tell you why, because once we held that if a legal wrong is done to a person or class of persons who by reason of their poverty or disability or socially or economically disadvantaged position cannot go to a court of law, then any member of the public or any social action group acting bona fide can bring an action in the High Court or the Supreme Court for vindicating the rights of the poor and the disadvantaged. And they can do so even by writing a letter to the court, because our social action groups, many of them, have very meager resources. Their only asset is their commitment to the cause of the poor. Therefore, we said that it should be enough for them to ignite the jurisdiction of the court by addressing a letter. And once we took this view, the portals of the courts were thrown open to the poor and the disadvantaged.
Would you say that public interest litigation was an attempt at an Indianization and indigenization of the system of justice?
Yes, in a way I would agree with you that public interest litigation which we brought in, that this new innovative strategy was really intended to meet the demands of the Indian situation, the social economic conditions prevailing in the country, the problem of poverty, ignorance, illiteracy, deprivation and exploitation, so that the whole justice system should be able to satisfy the hopes and aspirations of the common man in the country. That was the whole objective.
Yet you have gone on record, I think it was in 1984 and perhaps several times, in saying that in real terms the entire legal justice system wasn't able to ensure justice to the common man. Fundamentally, experientially, for most of us as citizens of India, the judicial system is not acceptable, is not accessible, it's experienced as being corrupt, as being available to the privileged, to the moneyed.
It is true that there is a very large backlog of cases in the Supreme Court and the High Courts. The causes are many. One of the important causes has been non-appointment of judges in time. There have been large delays in appointments of judges. I do not wish to go into the reasons why, because I am dealing with the whole issue very broadly. My own view is that if appointments had been made in the High Courts in time, perhaps the problem of areas would not have been so acute as it is today. You are right, in 1985, I said that the judicial system is on the verge of collapse. It is very much true that it is on the verge of collapse because we have not been able to tackle the backlog of cases. And people have been waiting for years and years before they can get justice, which is a very deplorable state of affairs. But there are many remedies for this. This is not a situation without remedy. But the charge or the criticism that public interest litigation would in some way divert the attention of the court from the other cases which are pending before it, I think the charge of criticism is baseless. My answer is twofold. Number one, how many public interest litigation cases come before the court as compared to the cases which come in the normal course? We have about 30,000 special petitions which are filed in the Supreme Court every year. As against that, public interest litigation cases are not more than 300 at the outside. Now, look at the figures. How can you say that 300 public interest litigation cases are diverting the attention of the court from dealing with those other cases which are coming in time? And number two, those cases which are coming before us are cases of persons who can afford. Can we tell the poor and the disadvantaged, on whose behalf these public interest litigation cases are brought, can we tell them that, well, we are sorry we can't attend to your cases because we have cases of the persons who can afford. Those cases are pending before us. We'll first dispose of those cases. Maybe 5 years, 10 years, 15 years. Till that time, you don't come to this court. The doors of the court will be closed for you because you just can't afford to have proper legal representation in the manner in which others are able to have. So the whole thing is so absurd, telling 80% of the people in the country that you can't come to the courts. Why? Because the other cases are pending. And secondly, it is not public interest litigation which is responsible for swelling the files of the court or for increasing the backlog. There are other causes which are responsible, and there are remedies, several remedies are there. But we can solve this problem of arrears, backlog of cases without much difficulty. But it is no answer, therefore, to tell the poor people that their cases will not come before the courts. Supposing they had the monies, or supposing there were public interest law firms, they would have brought their cases in the regular way.
One of the achievements of the Justice Bhagwati Supreme Court was the enforcement, the implementation in a sense of social justice, which was really the role, should be the role of an enlightened executive. What have you perceived the role and the relationship of the Supreme Court and the executive?
No, the ideal relationship to my mind would be that in regard to two matters, I would say. Number one, appointment of judges. Today, the system of appointment of judges is that the Chief Justice of India discusses the matter with the Law Minister or the Prime Minister, and a judge is selected for appointment on the Supreme Court or maybe in the High Court. It originates from the High Court Chief Justice and goes through the whole procedure. As against that, in the United States, you have the whole system under public glare. The judge to be is gruelly cross-examined by the Senate Judiciary Committee. My own view is that both systems are wrong. We should have a broad-based authority which will select the persons to be appointed as judges so that the antecedents of the person concerned are examined, his social philosophy, and in my opinion, the social philosophy of a judge is a very, very material thing. It is not as if law operates in a vacuum. Very often, constitutional decisions are value judgments, and the choice of values is very often dictated by the social philosophy of the judge. If there is a broad-based authority, maybe 5 persons or 7 persons, who can select the persons to be appointed as judges, then amongst, they may recommend 1 or 2 names or 3 names, I don't mind, and the government may select any one out of the 3. Or they may select only one and the government should be bound to accept it. Then we shall be able to have really good appointments so that everyone knows who is being appointed as a judge. I said in one of my judgments that I would not trust any single individual with power. He may be the Prime Minister or he may be the Chief Justice of India.
But in a sense, doesn't the Supreme Court enjoy almost unbridled power in terms of the judicial process? It is a handful of people accountable to no one who are appointed, as you rightly pointed out, without sufficient vetting, who wield absolute final authority as granted by the Constitution on all matters concerning law.
You're right, absolutely right. And that is why I always believe that the social philosophy of the judge is his likes and dislikes, biases and prejudices and predilections and his attitudes and his whole approach becomes very material. And fortunately in our country, we have the directive principles of state policy, which are the lodestar, the beacon light, which are supposed to guide all the 3 departments of the state in their activities. So the judiciary also is not on an uncharted sea. It is not as if the judiciary can do whatever it likes. Judiciary also has got to keep the Constitution in mind. And the judges have got to be on the same wavelength as the Constitution, in tune with the constitutional values. And if that's why we select judges who are in tune with the Constitution, the constitutional objectives, who are imbued with the spirit of the Constitution, then I do not see any harm at all.
The United States gives sort of tenureship to a Supreme Court judge for life. In Great Britain, it's still possible for a reference to be made to the House of Lords, and so in a sense it's a legislature which is the final word. In India, it is possible for a Supreme Court judge to be vulnerable in a sense to government pressures. There is the carrot of post-retirement appointments or the appointment itself. What is a way out of the Indian predicament so that the Supreme Court doesn't emerge or doesn't project itself as a unified opinion?
See, so far as the question of offering judges appointments after retirement is concerned, ideally it should be possible to give to the judges the same pension as their salary and then requisition their services at any time that the government wants or the Chief Justice of India wants. And it is not a very desirable thing for judges to be offered appointments which might possibly influence, if not overtly, covertly, if not directly, at least indirectly, their judicial thinking whilst they are in office. So far as the unified court idea is concerned, I find myself entirely in agreement with what you said. And I have said so several times in my course of my various utterances, judicial and extrajudicial, that today we have unfortunately a fragmented bench structure, as I call it. The Supreme Court sits in panels of 2 or 3 or sometimes 5. The result is that it is not possible to achieve uniformity of approach. And when constitutional issues are involved, which basically involve value judgments, it is always better that there is a certain amount of continuity of approach, certain homogeneity, compactness, continuity, uniformity, a sense of direction, which is lacking in the Supreme Courts in the last several years. I am not talking only of present times or my time or the earlier times. Throughout it has been, because you can have any 3 judges, the Chief Justice can select any 3 judges for a particular type or particular category of cases maybe. And that would depend, and that would ultimately influence the decision making. I'll give you only one example. Take for example labor cases involving industrial law. If you have one set of 2 judges or 3 judges, you might reach one conclusion. If you have another set of 3 judges, you might reach another conclusion. Not that the judges don't decide according to law, but the question is what is their perception of law, which is influenced by their social philosophy. That's why you always hear the pro-workman judge or pro-labor judge or pro-management judge. Now, one doesn't like to say such things in public, but there is no doubt that the social philosophy of the judge influences his decision making, and it must be recognized that there is nothing to be worried about or nothing to be ashamed about it. Because, and ultimately even in the highest court you find 2 judges or 3 judges taking different views from one another. Why? Because of their approach and their attitude, towards the particular subject matter.
Except that it becomes possible, for some reason, it's a public perception that it becomes possible for eminent lawyers to manipulate their cases before specific judges who might be sympathetic to their point of view.
No, that is why, you see, that is why the Chief Justice, at least when I was the Chief Justice, I had specifically earmarked panels for different kinds of cases, so that it was not possible for lawyers to manipulate that their case comes only before a particular panel or bench and not before another bench.
But to really say and to ask that if in your sort of long career in the court and in the judicial process, you have found for yourself a shift in your perspective or a philosophy or a judgment that you might have given 15 years ago and now a different perspective yielded a different judicial opinion?
It is very rarely, I would say. Very rarely, so far as my own judicial decision making is concerned. In the last 15 years, I do not think there has been any shift in my judicial thinking.
Or maybe that's too short a time span. I'm really seeking an evolution.
I do not think, because I believe, I tell you why. My own view is that a judge is not a mason, he is an architect. He must have an architectural view or vision of the law and the constitution. And he must steadily build, brick by brick, that edifice which he has in mind. A case which comes to him, every case which comes to him is like a brick. He places it in position so as to build that edifice of which he must have a preview. And then only he can really become a really constructive judge, a judge who can leave his mark on the future development of the law.
But looking back, can he ever feel he made a mistake?
It can happen. It has happened to me. It has happened to me twice, where I have acknowledged the error made by me in interpretation. That was not constitutional law. One was an income tax law, where I felt on further reflection that my interpretation was wrong, and I changed it, and I confessed in my judgment that I was wrong. But that was a matter of interpretation, it was not a value judgment. But so far as the constitutional law value judgment is concerned, I believe I have steadfastly stuck to certain norms, certain constitutional values.
Is it possible for your sort of personal, ethical, moral judgment to conflict with the letter of the law that you're obliged to enforce? And what would you do if that happened?
It is rarely that I have felt constrained by the letter of the law. Law is like a plasticine in my hands. I have by and large, I won't say in all cases, by and large I have been able to mold it as I felt justice demanded. And that is how I have advanced the human rights jurisprudence in this country. We read legal aid as a fundamental right, as a part of reasonable, fair and just procedure, therefore obligatory upon the state. Now the question was of right to life. Now life means life ordinarily. We said no, life doesn't mean merely physical existence. It means the use of every limb or faculty through which life is enjoyed, and it also includes the right to live with basic human dignity, with the basic necessities of life, healthy environment, because otherwise life would not be worth living. So we read these things into the words of the Constitution with a view to evolving certain component rights, as I call them, which are not specifically in the Constitution, but we evolve them by a process of judicial interpretation. That's how we can now interfere in environmental cases. Right to healthy environment is a part of the right to life. Therefore, the state cannot deprive a person of that right. So that is how law can be molded by the judges. There is no doubt about it. That is why I always believe in judicial activism, judicial creativity, and that is how we have advanced the whole entire human rights jurisprudence in India. Even bonded labor, where the question was, what is forced labor? We said forced labor doesn't mean merely physical force. It can also include legal compulsion, and more than that, even economic compulsion. Now, this is how you pour life and blood. See, the legislature provides a dry skeleton of the law. It is a judge who fills it with blood and flesh to make of it a living organism suited to the needs of the society. And that is why the judicial function is a highly creative function, highly exhilarating function. It's almost the creative joy of an artist when you write a judgment.
When you're not thinking about law, and when you're not being a judge of the Supreme Court or a retired judge of the Supreme Court and addressing yourself to legal issues and legal concerns, what interests you, what keeps you busy?
Well, I am in touch with a large number of social action groups in the country. They still come to me. I guide them, I try to help them, I try to give some sense of direction to them. So I'm
What
busy.
do you do for leisure?
I don't think I have any leisure at all.
When was the last
But my leisure in the sense that I always keep on working, meeting people, talking to them, traveling, delivering lectures, attending conferences. But apart from law, my interest is philosophy and Sanskrit literature.
Is there any area that you feel that you failed and would have liked to achieve and didn't while you were on the bench?
Yes.
What?
The administration of justice. I wish I had been able to do much more to improve the efficiency of administration of justice. And there, for various reasons which I need not disclose or discuss, I do not think I succeeded as much as I would have liked to. Maybe perhaps if I had greater cooperation from the concerned quarters, I might have been able to do much better. So far as administration is concerned. So far as judicial side is concerned, I have every reason to feel happy that I have been able to help my people. And for the first time, I feel that the common man knew his Chief Justice, which is more than any Chief Justice can hope for. That is the greatest reward which a Chief Justice can ever hope to achieve. To be known not by the lawyers, not by the intellectuals, but by the common man, the man in the street, the tribal, the landless peasant, and people in distress. They could feel that they could come and get justice from the Chief Justice. There is nothing greater than that.